Why the US allowing automatic job authorization for spouses of H-1B visa holders means for Indians abroad. The US government latest immigrant-friendly policy amendment is likely to be particularly beneficial for Indian women whose spouses hold H-1B or L-1 visas, as they will now be allowed up to 180 days auto extension on work authorization. The United States has agreed to provide automatic work authorization permits to the spouses of H-1B visa holders, a move that is likely to benefit the thousands of Indian professionals based in the US. This comes after the American Immigration Lawyers Association filed a class action lawsuit on behalf of immigrant spouses, many of whom have lost their jobs due to the long processing delays for work authorization. A U.S. court has directed the U.S. Citizenship and Immigration Services USCIS to allow up to 180 days auto extension on work authorizations for spouses of L1 and H1B visa holders. While L1 spouses will be given the extension without applying, the H4 visa holders will still have to apply for the extension after the employment permit expires. H4 and L2 visas, what's the difference? The US government latest immigrant-friendly policy amendment is likely to be particularly beneficial for Indian women whose spouses hold H-1B or L-1 visas, as they will not be allowed up to 180 days auto extension on work authorization. An H-4 visa is issued by the US Citizenship and Immigration Services to the immediate family member, spouse, and children under the age of 21 of H-1B visa holders. According to government data, over 94% of H-4 visa holders are women, and of these, around 93% are from India. L1 visas are non-immigrant visas that are valid for a relatively short time. With this visa, multinationals are able to shift foreign employees to their US offices for specialized positions on a temporary basis. The dependent spouse or unmarried children under 21 years of age of an L1 visa holder are issued L2 visas to enter the United States. L2 visa holders can acquire EADM employment authorization documents to find employment. What does this mean for H4 and L2 visa holders? The USCIS will now have to grant up to 180 days auto extension of on work authorization for spouses of L1 and H1B visa holders. But while L1 spouses will get the extension without applying for it, the H4 visa will still have to apply for the extension once their employment permit expires. Despite the plain statutory language, USCIS failed to grant employment authorization incident to status for L2. The other issues relates to H4, which work permit expires prior to the H4 status. This is the group that always met the regulatory test for automatic extension of EADs. But the agencies previously prohibited them from that benefit and forced them to wait for reauthorization. John Washington, one of Ella's litigation partners, said, "The move is likely to remove some of the bottlenecks of the USCIS policies, which forced many of the spouses of L1 and H1 visa holders out of their jobs. Significantly, a large proportion of H1B visa holders are IT professionals from India working in US firms. Previously, the Obama administration had given work authorization to some categories of H4 visa holders. According to government data, over 90,000 H4 visa holders have received work authorization so far. What led to the policy change? This comes after the American Immigration Lawyers Association achieved a historic settlement with the Department of Homeland Security in the case of Sargil Mayorkas, which was filed on behalf of L2 and H4 plaintiffs who sought reauthorization or extensions of employment. Sargil was an extension of an earlier pending lawsuit filed in March 2021, which also sought lawful status and work authorization. In the Sargil case, Ella argued that due to processing delays for work authorization, dependents of H1B and L1 principal visa holders were being forced out of employment. In fact, one of the plaintiffs of the case was an Indian named Divya Jairaj who came to the US to study and returned as the spouse of an H-1B visa holder. Forbes reported, concurrent with her spouse extension on August 25, 2020, she filed applications to extend her H-4 status on Form I-539 and EAD on Form I-765. The lawsuit states later lost her job because of agency inaction. This H4 visa holders is a group that always met with regulatory test for automatic extension of EADs, employment authorization documents. But the agency previously prohibited them from that benefit and forced them to wait for reauthorization. People were suffering, they were losing their high paying jobs for absolutely no legitimate reason, causing harm to them and US business. John Washington from the association said, according to PTI, the settlement reverses the USCIS previously policy which prohibited H4 visa holders from obtaining automatic extensions of their employment authorization during the pendency of their EAD application. It also allows L2 visa holders automatic work authorization based upon their underlying status, which means the spouses of executives and managers will not have to apply for EADs before working in the US. Thank you.